Welcome today to our webinar, Managing Cross-Border Sexual Harassment Investigations, Part 2 in Asia and Australia. For those of you interested in obtaining CLE credit, a code will be read later in the presentation, and there'll be a further slide where you can scan your camera on the QR code and get that all-important credit that you've signed in to listen to today. But hopefully it won't just be the credit that you've come to listen to, it's to listen to the expertise of our great lawyers and panel today from around Asia and Australia to talk to you about this very interesting topic. So with me today are my international employment colleagues. We have Catherine Weaver, a dual qualified English and Hong Kong lawyer based in our Hong Kong office. We have Erin Hawthorne, an Australian lawyer based in Melbourne. Rebecca Lim, a Singapore lawyer based in Hong Kong, and Leon Mao is our PRC lawyer based in Shanghai and Hong Kong. So for those of you who perhaps don't know us quite so well, Seifarth is an award-winning domestic and international employment firm full of lawyers who provide the full range of contentious and non-contentious employment law to support our clients both domestically within the US and across the world. Our investigation practice works closely with our employment colleagues so we can seamlessly navigate and run complex workplace investigations, sometimes involving both criminal and regulatory issues for our clients. So that brings me back to today's topic, managing cross-border sexual harassment investigations. We will spend a short amount of time looking at the various sexual harassment laws for employers. We're going to touch on some of the key jurisdictional differences that employers are facing when investigating these types of matters. And that will then allow us to spend most of our time talking through the workplace scenarios that we've drafted for your purposes today. If you have any questions arising out of the webinar, then please send them in and we will respond to you after the event. It's pre-recorded, we can't do it live, but we will respond, I promise. So with that in mind, can we please move to the next slide? And then to the next one, please. Where I think, there you are, you see all our nice faces and our names, but as we can see them on the screen at the same time, we can move straight, please, to slide 5. Thank you very much. So what we've done here, and you'll get a copy of these slides afterwards, so we've pulled together some of the key comparatives as to what the issues are that you will face in these jurisdictions. So with that in mind, I'm going to turn to Kat, if I may. Dealing with Hong Kong, can you please explain the differences here between direct and indirect sexual harassment? Sorry, Kat, you've done that old problem. You're still on mute, I'm afraid. To take you off. 2020.
Thank you. Exactly. One day it will click. Sure. So the difference between direct and indirect sexual harassment in Hong Kong is quite similar to the concept that you have in the UK. What we've got in Hong Kong is the Sex Discrimination Ordinance, and this is Hong Kong's specific anti-discrimination legislation that's related to gender. And it specifically prohibits sexual harassment in the workplace. So for direct sexual harassment, this constitutes any unwelcome sexual advance, request for sexual favours, or other conduct of a sexual nature in circumstances where a reasonable person would have anticipated that the harassed person would be offended, humiliated, or intimidated. And then for indirect sexual harassment, this is where there is a sexually hostile or intimidating work environment, and that's created by engaging in unwelcome or uninvited sexual behaviour. Examples of that would be things like displaying sexually explicit pictures or posters, wolf whistling, for example, or sexually suggestive comments or jokes that are not directed at anyone in particular, that are said out in the open. So that would be indirect. That's the difference between direct and indirect in Hong Kong.
Thanks very much. That's a helpful illustration, and those examples work well. Leon, does that distinction exist in the PRC?
Not really. Sexual harassment is more broadly defined in the PRC under the labor law, the employment promotion law, and the civil code. So it generally includes sexual harassment, against the women and men by means of words, texts, images, physical acts, etc., against their will. Thank you.
Okay, well, thanks for that subtle distinction. Moving to Singapore then, Rebecca, harassment is specified as being prohibited under the Harassment Act, but does it go as far as to define what harassment is? How do employers know what harassment is under Singapore law?
Thanks, Matt. Sexual harassment is not expressly defined under legislation in Singapore. However, and in practice, any threatening, abusive, or insulting words or behavior of a sexual nature would likely constitute harassment.
Okay, well, now we understand sort of the landscape that the law is working in. The other area that obviously comes up quite frequently is the employer duty, and these obviously vary around the world. So going back to you, Leon, how does the duty on employers, the PRC, to prevent and stop sexual harassment operate?
In China, employers are under a legal duty to prevent and stop sexual harassment at working places. The Protection of Rights and Interests of Women law, amended in 2022, imposed a positive duty on employers to carry out trainings on prevention and sexual harassment to all employees. And the failure to, discharge this duty is in violation of this law, and the employer may be ordered by the authority to take corrective measures, and failing which the managers or other individuals liable may be sanctioned. Thank you.
Got it. And are we seeing these laws being actively enforced against employers in any of these cases or claims?
Yes.
So we do see them. How frequently is this happening? Is this something employers really need to be concerned about? It's a hot topic for people like that in China?
In China, it's a crystal clear legal obligation, to conduct the trainings in this respect. But the law is silent on the frequency on the trainings. So it's, in fact, it's subject to the discretion of local labor authority. Yeah.
Okay, but it's definitely something they can't ignore, and employers be wise to very much put this into place and ensure that it works effectively.
Yeah, correct.
Okay, great. So, Kat, employer duty in Hong Kong. I can see there we said vicariously liable. How's it working? Is it any different to PRC?
Yeah, it's a bit different. Again, it's kind of similar to the UK, which might be obvious given the history of Hong Kong and how the law has developed here. So, in Hong Kong, companies can be found vicariously liable for the acts of the employees, unless they put in place and they demonstrate that they've taken all reasonable, practical steps to try and prevent the conduct from occurring. And what this usually means in practice is having a policy in place, a robust anti-discrimination or anti-sexual harassment policy in place, but also doing training. So whilst it's not mandated that you do training, if you want to try and avoid being vicariously liable, then it's advisable that you do training. And again, don't do it just once at the beginning. Don't do it as part of just the induction and forget about it. Think about doing it on a more regular basis, at least annually. And then also, I think things that can help with establishing or trying to move away from vicarious liability are showing that you do actively deal with sexual harassment complaints. So making sure there is form that you are addressing these issues. There are cases that have occurred, that you have taken action when these things have happened in the past. And all those things can help when it comes to trying to move away from vicarious liability. All of that said, in most of my experience of dealing with cases in Hong Kong, an employer will generally accept vicarious liability. So they will, it's not often that they hang out an individual in the organisation to dry. They will generally come along and defend the claim, and the person, the manager, whoever it is, the individual in the organisation that has been involved or alleged accused of the sexual harassment, will be with them in that case, and they'll be defending the case together. But it's not often, I find, that a company will actually say we don't have vicarious liability. It's all on you, individual. We've got nothing to do with this.
Got it. Okay, so very much obviously keep in mind, show me it works rather than just tell me it works. And the more you can show and got that evidence, the better it will be. Singapore then. So Rebecca, I'm just reading the slides, and so we can see there's no statutory duty to prevent, but then employers at the same time are encouraged to nevertheless develop a prevention policy. How do those two sort of work in practice? What's the reality we're seeing on the ground?
That's exactly right. There are no strict legal requirements for employers to take action in Singapore, but the Singapore government has issued various recommendations or advisories to encourage employers to take initiative in preventing workplace harassment, including sexual harassment. So, for example, the Tripartite Advisory on Managing Workplace Harassment contains guidance on the prevention of harassment in the workplace and guidance in relation to the drafting of a harassment policy. The advisory also provides useful information on how employers can implement reporting and response procedures, as well as guidance on the investigation processes that they can put into practice.
Got it. Before we move then over to Australia, I just want to touch on a broader point and go back to you, Kat, if I may. Are we seeing this type of policy being required in other sort of Asia Pacific countries?
Yeah, it's starting to come in, and some countries have actually had it for quite some time. India, for example, have had their legislation around preventing sexual harassment and bringing in policies since, I think, 2013. So you've got India, you've got Japan, you've got South Korea. So South Korea, you've got to have a procedure in place to deal with allegations of sexual harassment. And in India and Japan, you are mandated to have policy in place. So I'll talk about India a bit more, because I think India has put a lot of time and effort and attention on trying to deal with sexual harassment in their jurisdiction over the last decade or so. And they've got some very clear rules in place to try and help prevent sexual harassment in the workplace. So their main law, as you might have heard of, it's often referred to as the POSH Act, and that's Prevention of Sexual Harassment Act. And it mandates organisations in India to take some specific steps to try and ensure compliance. One of those is, as mentioned, drafting a prevention of sexual harassment policy. So you've got to put that in place. You've got to outline how you're going to try and prevent sexual harassment, the processes for reporting complaints, and the procedures for investigating and reaching resolution. You should be updating your employment contracts too, to make reference to your POSH policy, and also detail that you're trying to maintain a harassment-free workplace, and what the consequences are for violating the policy. And then you've also got to put in place an internal committee. So if you have an organisation with 10 or more employees, you've got to set up an internal committee which is responsible for receiving and addressing complaints relating to sexual harassment. And then you also have to have training in place. So organisations must conduct awareness programmes to educate their employees about their rights and responsibilities concerning the prevention of sexual harassment. And then finally, again, if you're an organisation with 10 or more employees, you've got to submit an annual report on your compliance with the POSH Act. And that report provides information on the number of complaints received, resolved and pending, as well as details about awareness programmes that have been conducted during the year. So if there's any attendees of this webinar who are considering opening up in India or getting near to the 10 employee mark, then they should pay particular attention to their obligations under the POSH Act, because failure to adhere to the rules also does lead to potential fines.
Thanks for that. That really is quite prescriptive, isn't it? It's really taken it to a much further level. I'm just going to leave Asia for a moment in its perhaps narrower or broader sense, depending on how you want to define it, and move to Erin, if we may, on our next slide, to Australia. There we go. So Looking again, Australia's gone and done things on its own, and it's got a few quirks I can see, Erin, in here. In particular, there's liability potentially to employers, not just under employment law, but health and safety law. Can you just sort of deal with that and explain how those laws apply and run in parallel to the employment issue here?
Yeah, it is a pretty complicated regulatory landscape in Australia, where we have this issue being regulated under multiple sources of law, human rights laws at state and federal level, workplace laws, and also under work health and safety laws, again, at state and federal level. The key definitions are similar in some respects to what has been described for Hong Kong, and some of the regulatory guidance contains a similar level of prescription as we've just heard of for India. There are positive duties that apply under our human rights laws to take reasonable and proportionate preventative measures. But to come, Matt, to the question you asked about, one of the things that is probably a little bit different in Australia is that our work health and safety laws require all employers or people conducting a business or undertaking to take reasonably practicable measures to prevent work health and safety risks, and sexual harassment is increasingly recognised as a specific type of safety hazard in terms of mental health and well-being. And what that means is that employers can be criminally prosecuted for breaches of the work health and safety duties if those breaches are connected with sexual harassment. We're seeing a lot of our work health and safety regulators at both state and federal level step into this space and be quite active in terms of issuing guidance around their expectations on employers, which again really set a very high bar for the way that businesses are supposed to both prevent unlawful conduct from occurring, but then also respond if it does.
Okay, so yeah, a lot to deal with, and obviously potential criminal risks as well there. That's always going to focus people's mind when it comes to compliance. But in addition, we see employer duty obviously also in place in Australia, a positive duty to prevent. Have we seen that being actively enforced? I know it's been around for a year or two now, and perhaps it would be helpful to hear if there are any sort of lessons learned that what works well and what hasn't been working well in terms of what employers should be doing in this space.
Because of the multiplicity of regulation, it can be tricky for large organisations or small organisations to know where to start. And historically, one of the things that we've seen in Australia are that the human rights specialty is often led by an expert team, and the work health and safety specialty is often led by a different expert team within organisations. So probably one of the big call-outs here is that businesses are increasingly expected to treat this as a blended issue, having regard to both the human rights obligations and regulatory guidance, and also the work health and safety obligations and regulatory guidance. And so taking a siloed approach tends to duplicate effort and can lead to some confusing multiplicity of policies and procedures internally. One of the big call-outs is the requirement to work cross-disciplinary to ensure that workplaces are setting a safe, respectful and inclusive culture, and also ensuring that if and when there are issues that arise, they take a trauma-informed response to complaints that prioritises individual worker well-being as part of the corporate response. Another key takeout is that both the safety and the human rights regulators expect a lot from senior company leaders, from company officials, executives, and senior managers. They're expecting that senior groups of decision makers set the tone from the top and are actively involved in creating this safe, inclusive culture. Another takeout are that for global corporations, up until quite recently, there has been a convenience in having standardised policies and procedures that set the bar at the appropriate level across the jurisdictions in which they operate. Under the new regulatory guidance, it's going to be important for companies that operate in Australia to have local policies and procedures that account for the local definitions and the local regulatory expectations on businesses, ensuring that the policies and procedures comply with and discharge the types of recommendations that our Australian regulators are issuing will be critical to managing risk for global businesses that operate in Australia.
Okay, that's really helpful. And have you started to see, or is it too early to see any sanctions coming through now against employers for breaching this duty?
So we've probably got two separate types of sanctions here. The first type has been around for a long time, which is that if and when sexual harassment occurs, a claim will be made potentially both against the individuals, but also against the company, relying on the principles of vicarious liability. So that type of sanction has been around for a long time. And what we've seen are that those types of claims are commonly run with allegations that the victim of the harassment has been sufficiently harmed that they will be prevented from working again or for an extended period of time. And that leads to damages claims in the hundreds of thousands or millions of dollars. So that type of sanction we've seen a lot of, and it's been around for a long time. What is probably newer is a separate sanction for breaching the positive duty, which is typically in the form of a fine or a prosecution. Because the positive duty is relatively recent, we haven't yet seen many of those cases, but there has been one recently where a company was fined for failing to take preventative steps. So we are seeing these claims being brought, and we can expect to see more of them in the future, given the high profile nature of this issue in Australia and given the positive involvement by the regulators in trying to run test cases to set the standards.
Thanks, Erin. That's very helpful. I want to move on now away from the specific substantive laws and on those jurisdictions and come on to some of the issues that arise when we come into those investigations. So let's move forward with the slide, if we may, to the next slide. There we go. So what we've done here is try and be helpful to you all by putting a comparative table together of some of the key issues that are likely to arise when conducting an investigation of this nature. I'm not going to draw on every single point here because hopefully we will touch on those in more detail in the case study, but I just want to bring out and highlight some of the key differences that I think you may find interesting. So if I may, Leon, coming to you, looking at privilege, it seems that PRC doesn't have attorney-client privilege, unlike Hong Kong, Singapore, and Australia. So is there a way that employers can protect themselves and the materials that arise in these sorts of investigations from disclosure in any way, or to keep them confidential? How would it work?
Well, in China, we would usually rely on confidentiality provisions to protect the sensitive information obtained during the investigation process. So under the PRC lawyers' law, attorneys have an obligation to maintain confidentiality regarding their clients' trade secrets and personal privacy, even though this duty does not constitute absolute privilege protection. In internal investigations, the application of privilege primarily, manifests in the confidentiality requirements for sensitive information obtained during, the investigation processes. And ensuring the non-disclosure of such sensitive information is essential to protect both the company and the employee's privacy. Thank you.
Okay, well, that's helpful. Look, I'm not going to go through all of the privilege points because I'm also conscious of time, but I did want to just come to you, Kat, if I can, just in terms of any quirks in any on the issues of privilege in any other Asia Pacific jurisdictions rather than just Hong Kong and Singapore here.
Yeah, because as you identified, Hong Kong, Singapore, they follow common law principles around privilege. So you've got your legal advice privilege, you've got your litigation privilege. I would say that sometimes I think it can be a little bit tricky to argue that either of those apply in all investigation situations, because they may not always be for the purpose of legal advice. It might be that you've just been asked to make some factual findings, and also with litigation privilege, it may not always be reasonably contemplated that litigation is going to be arising, especially if you're doing kind of a preliminary look into maybe workplace culture issues. But thinking about the quirks in Asia Pacific, so like China, there's a few other jurisdictions that don't really have law, albeit common law or specific law, that recognises legal privilege. So you've got Taiwan that falls into that bracket, and Japan and Vietnam. And then in India, you've got legal privilege, but it generally only applies where local lawyers are involved. And I mean those who are called to the Indian bar. And there's also split case law on whether privilege can extend to in-house lawyers in India. So it's worth bearing that in mind when you're investigating matters in India, where you want to exercise privilege over the investigation or part of the investigation. You've got to think about how and when you might want to involve Indian lawyers, and also think about when you get in-house lawyers involved. I mean, you can have them involved, and you can have external non-Indian lawyers involved. But if court proceedings are contemplated, then you might want to have some kind of liaison with local lawyers. It's probably advisable.
Okay, that's helpful. Just before we leave privilege, just pass over to you, Erin. Anything you want to add there in terms of anything people need to keep in mind from the Australian side?
In Australia, legal privilege can apply to any communication that is for the dominant purpose of legal advice. So it can apply very broadly in an investigation context if the investigation taken as a whole is for that dominant purpose, and that is the purpose of each of the communications that occur in the course of that investigation. A lawyer's involvement can be very useful in establishing privilege, but particularly if there's anticipated litigation, it may not always be necessary on each individual communication. In Australia, the question that organisations often trip up on isn't so much whether privilege applies as whether or not it has been waived, because it's quite easy to waive privilege. For example, using legally privileged information for a non-privileged purpose, such as making a disciplinary decision or internal governance, can be sufficient to waive privilege in the original communication, even if that was properly set up as a legally privileged communication. Another way that organisations can sometimes accidentally waive privilege is to make promises or representations that are inconsistent with the maintenance of that privilege in the original legally privileged document. So, for example, promising people that they'll get access to all of the information against them, or suggesting that they're going to get a copy of the final investigation report. Those are things that can sometimes result in companies accidentally losing privilege, even if the investigation has been set up properly as a legally privileged investigation.
Got it. So tread in caution. It seems like always best to pick up the phone, I think, on that one, just to double check what's going to happen to that investigation before it starts in terms of privilege. Leon, I just want to come to you on one question here, and then we're going to move to the next slide. But I can see there's a positive obligation on employers to implement procedures to investigate these sorts of claims, which we don't see in Hong Kong and Singapore as such. Just tell us a bit more about that. What does that mean?
In China, employers are legally required, to conduct investigations, to set up investigation procedures. That means the employers should have whistleblowing channels set up out there ready for the employees for their whistleblowing purposes when there is a dispute in this respect. So that's a clear legal obligation. Yeah.
Okay, so you must. Does that mean every single piece of information that comes to the company's attention must be investigated, or do they have a discretion as to when they can do that?
Not really. That only for those whistleblowing message regarding sexual harassment will apply. Yeah, not all voices from employees.
Okay, thanks. That's very helpful. Let's move to, if we may, the next slide. And I'm going to do it in the same sort of way, just draw out one or two points here. Erin, just going back to you for a moment. Procedural fairness in the course of the interview and the investigation, I suppose, more broadly. How does that sort of apply? What does it look like You know, what sort of things should people be thinking about, perhaps in terms of pre-interview disclosure, etc.?
Procedural fairness can be required if the employer has made a promise in a contract or a policy to apply the rules of procedural fairness, or natural justice it might be called, or something along those lines. In addition, in Australia, many employees have statutory claim rights if they've been dismissed for what's called an unfair dismissal. That's the most common type of claim brought by an employee that's been dismissed in Australia. And if a claim like that is brought, then there is a real risk that the National Labour Tribunal here will be critical of any investigation that leads to a dismissal that did not include the basic elements of procedural fairness. So there are generally 3 steps required for procedural fairness. The first step is that our decision maker is free from either actual or the perception of bias in relation to the matter. 2, the person, the respondent to an investigation typically, is given prior notice of the fact that there are allegations against them that could affect their interests, so that they're aware of the significance and importance of the matter. And then the final requirement is that that person is given a reasonable opportunity to respond to information about those allegations that is relevant, credible, and significant, and that their response is genuinely considered and assessed and taken into account before any final decisions or findings have been made. In a recent claim that went to the Australian High Court, an employee was awarded over $1.4 million in damages for employer breaches of procedural fairness in a misconduct investigation. So getting this wrong can represent a high cost to employers, even leaving aside things like our unfair dismissal risks.
Wow, that's a pretty hefty fine, isn't it, for people being perhaps careless or not just thinking through things as well or as completely as they could be. Let's leave that slide then, if we may, and move to the next one. Excuse me. Thank you. I just want to bring in Rebecca here, if I may, and we're going to talk about the sort of interim work arrangements, because that's always an issue when a matter like this comes up. There's a big sensitivity around it. There's a big conversation immediately in terms of, can we or should we suspend this person? And there's lots of ramifications on both sides as to why you may or may not want to do that. Just talk about, if you may, some of those measures that could and can be adopted in Singapore.
Thanks, Matt. That's right. So it's relatively common for employers in Singapore to place employees on suspension during a workplace investigation. In fact, the Singapore Employment Act expressly provides that an employee may be suspended, but this is subject to the suspension not exceeding a period of 1 week unless approval from the Ministry of Manpower has been obtained. An employee may also be placed on garden leave during the period where a workplace investigation is conducted, and the main difference would then be that an employee who is placed on garden leave would receive full pay during that period.
Thanks. Erin, I'm guessing there's going to be another little quirk over in Australia here on this one. What are some of the things employers need to be wary of in terms of putting in place these interim measures? How can they get tripped up?
Yeah, I think definitely having regard to the risks involved. So the risks of people not being able to work productively together, and the risks of a perpetrator remaining in a position where they could do harm to others. Again, you're not prejudging the issue by considering the risk. In fact, you're leaving all options open. You're just saying, do we need to consider an option such as suspension that Rebecca was referring to a minute ago as a precautionary measure while we figure out exactly what's happened here. One other issue to be aware of is the potential optics and difficulties involved in a measure, which is often, in my experience, intended to protect someone who claims to be a victim. There are potential risks to organisations of having a victim have their job or work interrupted in circumstances where the perpetrator continues as normal. Often, in my experience, someone who's bringing forward an allegation might temporarily request, for example, to work from home. They might say that they don't want anyone to be aware of that situation. But even if that's what the person initially requests, it should be considered But organisations can find themselves in a situation where that later leads to claims of retaliation or victimisation, of bullying or ostracisation in the workplace. So just be cautious of an interim measure that appears to disadvantage a victim rather than a perpetrator, because that can have unintended consequences in Australia.
Got it. Okay, good points to keep in mind. Let's take those with us, bank our knowledge from these slides and see how well people can apply it to the case study then if we move forward in the next deck. Thank you. To the next slide. Right, it's on the screen. I'm going to read it out once and then we're going to go and ask some questions. So we have a US corporate hosts a Christmas party for senior management at its London office. Key individuals fly in from various jurisdictions, including the USA, Hong Kong, Singapore, PRC, Australia, and India. So we've got a big, broad selection there, some of whom attend an off-site after party. 2 days after the party, an HR executive in the USA receives a call from Jamie, a senior manager based in Hong Kong, claiming sexual harassment by Alex at the party. Specifically, Jamie said that Alex, having kissed and hugged other staff, had tried to give Jamie a kiss on the cheek and pretended not to hear Jamie's protests. Alex also tried to kiss and hug Jamie at the after-party drinks at a local bar when other staff were also present. Alex is Italian but is based in Australia and sits on the company's executive board for APAC. The morning after the party, Jamie received a work email from Alex which said, "Thanks for a great night. Hope to see you soon. Kiss, kiss." Alex also sent Jamie a message to her personal phone. "I'm heading back to Australia next week. Would you like to meet again this week?" Wink, smiley face. Jamie wants to raise a formal grievance but is concerned of retribution due to Alex's position in the company and has asked you not to share this with anyone else. What should you do? Right then, so here we are, US corporates faced with this issue, lots of moving parts and lots of people in different jurisdictions, both now and when the issue took place. So some of the immediate steps the company's going to have to be thinking about is understanding what the lay of the land is in these countries for the key players and these protagonists in this scenario here. So I think having picked up that phone call, one of the things they're going to want to be doing, isn't it, is to getting a sense of what the law and the reality of dealing with these claims are going to be in the respective jurisdictions. So with that in mind, I'm going to turn to you first, if I may, Rebecca, just to deal with this in a sort of broader sense. Does the fact that Jamie has said not to share her disclosure with anyone else make a difference here as to whether you investigate? If this happened in Singapore, would it make a difference or not?
No, it wouldn't. And I think it wouldn't in many jurisdictions as well. In the context of Singapore, where investigations into workplace harassment issues are involved, the Tripartite Advisory on Managing Workplace Harassment, which has been issued by the Singapore Ministry of Manpower, provides that the identities of the alleged harasser, affected persons, as well as the informant should be protected unless the employer assesses that disclosure is necessary for safety reasons. So there's some things to think about in terms of whether you reveal the identities of relevant personnel, but it doesn't prevent you from conducting an investigation.
Okay, that's helpful to know. So Kat, obviously Jamie's wants to raise a formal grievance, but is equally and understandably here concerned about it all getting out and going around the company and wanting to keep it confidential. Is there anything practically you can be saying at this very early stage to Jamie to allay her concerns?
Yes, this is a very common scenario, and I think there's always a need to be super careful during an investigation, even at this early stage, not to be promising outright confidentiality to anyone, including the complainant. I think it's fine to say that the allegation will be investigated confidentially and that nothing will be disclosed unless it's necessary for the purpose of the investigation or any ensuing disciplinary processes or legal proceedings. You've got to make that clear. So you've got to say we're going to keep this as confidential as possible, but of course, it may be necessary to share some of the details. But the way we could try and allay Jamie's concerns is by reminding her of the company's anti-retaliation policies, assuming the company has these in place. And also the laws of Hong Kong, which is where Jamie is based, they also protect her against any kind of victimization for raising a complaint or claim of sexual harassment. So there should be some comfort in that. I know quite often it doesn't necessarily allay all the complainant's concerns, but they should know they shouldn't be retaliated against, and that the company will do its utmost to keep matters confidential to the extent it can.
Okay, that's good to know. Erin, we've got Alex here, the person who's being complained about. He lives in Australia, sits on the company's exec board for APAC. How does the company work out whether, for example, now, does Australian law apply to Alex, or are we going to be looking at what really relates to the aggrieved person here and what's happened? What's your advice?
Certainly raises some complex interaction of law questions in this scenario. From a fundamental principled basis, Alex is working in Australia. Let's assume that he's an Australian employee. So Australian law will apply to Alex in respect of their employment in Australia. And the company that employs Alex could be vicariously liable under Australian law for his actions. Leaving aside that issue, though, in my experience, this would be likely to be dealt with as a company code of conduct issue at the first instance. We're talking about somebody who sits on the APAC executive board. This is a very senior person within the organisation. And so often a factual investigation would first focus simply on what has occurred, the facts, what did Alex do, what didn't Alex do, and then there would be a separate assessment of whether or not, based on the findings of that investigation, Alex, again, as a senior executive, has actually complied with the conduct standards that the company expects from him, regardless of where he's physically located at any particular point in time. The question of which law technically applies is definitely relevant, but it's more likely to arise if, for example, there's a legal claim against the company, rather than dictating what the investigation response should look like.
Got it. So, I mean, it's important to work out what law may apply, perhaps simply, so we understand that the investigation process, go through those earlier slides we just chatted about, will privilege apply, not apply, but ultimately, and I think that's the key point, isn't it here? It's the codes of conduct. Go back to basics, work on that. If there's no breach, then just test whether there's a jurisdictional quirk, that if no breach of policy, is there a local breach of law? Does any jurisdiction here take the view that because it happened off-site or outside of work hours, that the employment laws won't apply to this individual, i.e. the employer's not liable because it happened outside of the office? I'm seeing no shakings of heads there. That's fine. And Kat, there's no other quirks that you're aware of in some other Asian jurisdictions where that may kick in or not?
No, certainly not in the kind of common law jurisdiction. So if there's sufficient connection to the workplace or employment, then then there will be, the laws will apply in relation to anti-sexual harassment. So the fact that it's a company-sponsored event, it's an unofficial work event, or it goes on later, it's an after party. If there's still that substantial link there, then generally the laws will be applicable.
Yeah, there's always that problem,
works.
isn't there? Factually, I suppose, ultimately, when does the party actually end? Is it when the taxis are called, etc.? But that's something we have to wrestle with as the scenarios move on. Going back then to one of the things I want to just sort of tease out a bit more, and maybe I'll turn to you, Leon, is around cultural sensitivities here and what's deemed appropriate or not appropriate. You know, we obviously are familiar with some European countries more demonstrative than others in how they greet each other. Looking at this scenario, here, kisses on the cheek at first instance, despite a protest that they didn't want to be greeted in that way. Are there any peculiarities or just good sensitive cultural issues that we should be employers should be thinking about in the PRC on scenarios like this?
Yeah, in China, you know, cultural differences in certain industries may make a difference here. For example, based on our previous experience, you know, culture in a video gaming company is normally regarded as more open than other traditional industries. So that makes a difference when we assist the company to investigate and to consider the disciplinary action out there. So yeah, in conclusion, the answer is yes. Yeah.
I see, but just because it's local custom, does that mean that it's acceptable if the person doesn't want to be treated that way? What do you think about that, Leon?
Local custom normally does not make a significant difference here from the sexual harassment perspective in China, and we have seen several cases in this regard, and the person cannot claim, well, this is my excuse is the local custom, so I should not be responsible. Yeah.
Okay, great. Kat, any cultural sensitivities companies should take note of when conducting investigations, perhaps in places like Korea or Japan?
Yeah, so this investigation is likely to cover employees in various jurisdictions. And so it's important, I think, to understand the cultural nuances before you start the investigation. Some jurisdictions take a much more robust approach, like a court-like way of dealing with investigations, and other jurisdictions are much softer. So, for example, it's important in places like Japan and Korea not to go into an investigation in an accusatory manner with a harsh tone or with any kind of premeditated ideas about the outcome, because amongst other things, you might be accused of harassment, as in the way in which you've conducted the investigation might be deemed harassing. And then in many Asian jurisdictions, they also care a lot about hierarchy and face. So it may not be appropriate for an investigation to be conducted, say, by someone internal who is lower ranking than the person they are investigating, as they may not be able to ask the questions properly, and the interviewee may not feel comfortable participating properly or fully as well. So that's why it can be useful to use an external firm for investigations in those jurisdictions. Other things to think about, the language of the country in which you are doing the investigation. So we're talking about the literal language as well as the words that are used. So some countries care a lot about honorifics, the way in which you address people. So you make sure you know what those are before you go into an investigation there. And then also the language itself. So you need to make sure that the people that you are interviewing can speak English, if that's the language it's going to be conducted in, or if they don't speak English or they're not fully comfortable in English, then you need to make sure the interviewer speaks the language of the person they are interviewing, or has somebody in the room that can translate, or translation software. Few other bits and bobs that I think about. There's sometimes an ambush approach. So some jurisdictions in Asia favour the ambush approach, by which I mean you give very little notice that the investigation and interview is going to take place. You don't give any real information in advance, and you go in and just ask them questions in an ambush way. And other jurisdictions, that would go against the rules of natural justice and due inquiry. So yeah, a few things to think about from a cultural perspective.
That's really helpful, and obviously the gender perhaps equally as to who's interviewing, and the sensitivity of the subject matter, and particularly training on those sort of very sensitive issues to take into account. Erin, just going back to the scenario, if we can, if Alex was to argue here, oh, it wasn't my intention to make Jamie feel uncomfortable or to feel like they were being sexually harassed, does that make a difference as to what he intended?
It doesn't make a difference to the question of whether this was sexual harassment or not. It might be relevant to compensation. So under Australian law, sexual harassment occurs where there's unwelcome conduct of a sexual nature with an objective test based on whether a reasonable person would anticipate the possibility that the victim would be humiliated, intimidated, or offended. There's no onus on the victim to protest, but here Jamie did protest, so that would be relevant. Local custom is helpful as background and context, but the question isn't what Alex intended. Under Australian law, many cases have confirmed that sexual harassment can occur even if the perpetrator didn't intend to sexually harass the victim. So sadly, that's not a defence here.
Okay, that's helpful clarification and a good point to note. Before we leave this slide, I just want to go back to Leon. And I know that we don't necessarily have text messages going back and forth through somebody who's based in China here, but this is something that came up not so long ago in a matter I was dealing with, and I think it's important to draw out. So we see there's a text message Jamie receives on her phone sent from Alex. So I'm just going to put this back to you, Leon. Let's pretend this is like on WeChat, which is the equivalent of WhatsApp for anyone else who didn't know that. What are some of the problems we've got here? If the company wants to image that phone in the PRC and then send the content, for example, back to the US to have a look at it, or even to be shown it on screens, how easy is it to transfer that sort of data outside the jurisdiction?
Well, cross-border data transfers and reviews are subject to strict regulations in China. So under the PRC data security law and personal information protection law, the transfer of certain cross-border, data, for example, emails or the WeChat messages you just mentioned, must meet specific conditions, including obtaining the data subject's consent, conducting data security assessments, and signing data protection agreements with the recipient overseas. So a new regulation issued in 2024 provides specific exemptions for security measures under certain circumstances. Scenario one is that, well, if it is necessary, to provide personal information abroad to conclude or perform a contract in which an individual is a party. For example, it is a must to provide individuals, personal information to the headquarters, for example, in US to conclude the labor contract. Then it is exemption to go through this, security, procedures under the privacy laws in China. Another exemption, scenario is that, well, if the company needs to provide employees, personal information abroad for cross-border human resource management, and as we know, many multinationals, they manage HR data on a global basis. So all the HR data goes to headquarters, goes to the server in headquarters for the HR management purpose. And that is also, exemption to go through all these, security, procedures in China. And another, exemption scenario is when the company, needs to provide the personal information abroad in emergencies to protect the life, health, and property safety of natural persons. Well, it is also really waived from the legal obligation to go through all these security assessment procedures. So in conclusion, that we should always ensure the cross-border transfer of certain sensitive data, including the personal data, including the messages, emails, is legally compliant. And the company should always work with privacy experts in different jurisdictions to spot the potential risks for the proposed cross-border transfer of data and to minimize the risks. Thank you.
Thanks, Leon. Look, well, let's move on to case study 2. We have about 10 minutes to chat through this. In January 25, the company commenced a restructuring project which resulted in redundancies across the globe. Jamie was one of the impacted employees and was notified of the redundancy yesterday. You receive an angry call from Jamie saying she had met her 2024 performance targets and that the only reason she was selected for redundancy was because she had rejected Alex's advances. Jamie said she would file a complaint with the local authorities. So a few things to unpack there. I'll come back to sort of law and policies a bit later on, because in a way we've chatted through that topic a little bit in part 1. I'm just going to bring in Kat, if I may. So is Jamie protected from being made redundant at this stage while the investigation's still ongoing?
She's not protected per se because she's going through an investigation, but she does have protection, as mentioned earlier, against being victimised because she raised a complaint of sexual harassment. So she's protected under the Sex Discrimination Ordinance, and she's also protected against being dismissed by reason of her giving evidence or information in any proceedings or inquiry in connection with the enforcement of the employment ordinance or in relation to work accidents, which this isn't, but or breach of work safety legislation, which this potentially could be. So you need to be mindful of that too. And if the company does intend to make Jamie redundant during this process, then it should make absolutely clear that the complaint of sexual harassment is not a consideration in the selection process. There shouldn't be any kind of causal link between the redundancy decision and the fact that she's raised her complaint. So if she is selected for redundancy, this should be this should be on objective reasons only. It should be objective, fair selection criteria. But from an ER and kind of PR perspective, the optics may not be great if you are partway through an investigation and it's not wrapped up before the redundancy decision. So I'd always suggest that a company does try to reach a conclusion on an investigation before they make any announcements on redundancy. But if the redundancy has to happen really quickly, then practically the thing to do would be to speak to Jamie about a mutual separation agreement. So you'd want to give, you'd probably be giving an enhanced redundancy payment anyway. Most companies do. And if you do so, it would be a good practice to ask her to sign a mutual separation agreement under which she'd waive any potential claims.
Got it. Rebecca, then, and it may well be that Kat's touched on some of this already, but does Jamie's complaint have to be dealt with here as a grievance, or can it be dealt with during the redundancy consultation process?
It could be both, really. So with regard to the redundancy, typically in the redundancy consultation process, Jamie would be informed of why and how the selection process was done and the objective reasons as to why the role is being made redundant. So it would be no different from a conversation you would have with any other employee whose role was being made redundant. In terms of the grievance itself, it should be dealt with in accordance with the company's grievance policy. And again, as with any other grievance rates, the process should be applied as is based on what is stipulated in the applicable grievance policy.
Got it. Okay, Erin, if I can bring you in then. Given that Jamie's met her performance objectives, does she have to prove a link of causation between reporting the harassment and then later being selected potentially for dismissal through the redundancy process here?
If we assume that Australian law applies to Jamie and that she can bring claims locally, the most likely claim that she would bring is something known in Australia as an adverse action claim, which has a reverse onus of proof. So aside from being made redundant, Jamie doesn't have to prove anything. It's actually the company that fully bears the onus of disproving causation. This typically requires an organisation in Australia to identify all of the people who were decision makers in relation to Jamie's redundancy, and then call evidence that proves each of those people only acted for lawful reasons and not because of Jamie's complaints or inquiries.
Okay, so it's all on the company to rebut here in that scenario if Australian law applies. Kat, just coming back to you, and perhaps the slides can go back on the screen while we're still chatting. If Jamie's already filed the complaint, though, with local authorities, how should the company react in that scenario in terms of, do they pause this redundancy restructuring? What's the best way to move forward, knowing that the local authorities have this in there?
Yes, well, there's various local authorities that an individual could go to in Hong Kong for anything to do with discrimination. Generally, they'll go and make their complaint to the Equal Opportunities Commission first in Hong Kong, and that commission has the power to investigate a complaint and conciliate if both parties want to conciliate. The employee doesn't have to file their complaint there, though. They can go straight to the district court if they want to with their complaint. Or if they think there's been a breach of the employment ordinance or the employment contract, say, for example, there was a contractual anti-sexual harassment policy that had been breached, then they could also make a complaint to the Labour Department or the Labour Tribunal. And if that happens, then of course the employer needs to respond. So if the EOC sends them some questions in relation to the investigation that they are doing, then they have to respond to those. And if they want to, they can go to the conciliation meeting and deal with it there. Similar with the Labour Department, you would get called to a meeting to kind of explain yourself. And you can't really stop that happening. You can't stop that time frame. That's going to happen anyway. In terms of what you do with the internal process, with the redundancy and investigation, there's no reason to pause it necessarily. You can carry on with it if you want. You can go ahead and make the redundancy. You can go ahead and conclude the investigation. But thinking about it again from maybe a cost and practical perspective, if you haven't terminated employment at that point in time, you may want to put a pause on it, just because then it reduces the amount of potential compensation the individual could get, so Jamie could get in the circumstances, because if she's going to be bringing a claim, then she needs to prove what her losses are, and if she's still employed at the time, then obviously her claim can only go so far in terms of compensation. So from a practical perspective, you might want to pause it, but you don't have to. You're not legally obliged to pause the redundancy process or the investigation process.
Interesting. So I'm just going to put everyone on the spot, if I may, because certainly on other matters, once local authorities get involved or regulators, sometimes they get very upset if you're investigating in parallel to them, or they want to run the investigation, or they want to have some input into the investigation. Keeping this scenario in mind, does anyone's jurisdiction that we're talking about here have an authority where you feel it's wise to sort of defer to them a little bit, to say, before we carry on with this, are you happy with us doing the investigation this way or that way? Is anyone saying that that's the right way to proceed in their country? I don't see anyone jumping in there. So that's good to know. Really, the discretion is really down to the company to manage that investigation as it sees fit, based with those circumstances in mind. Right. Well, with that said, we have come to time. I want to just move forward in the slide to the all-important QR code that I promised people they would receive at the end of this investigation, and just to thank all of our panel for their contributions to bring this topic, I hope, to life, and to provide you with some insights that perhaps you didn't have before about managing these sexual harassment investigations and claims across borders in Asia and Australia. As I say, if you have any questions, please feel free to email us. We're going to scan to the next page where there's our email addresses and contact details. Please do get in touch, or send us any messages to your usual partners that you have relationships with at SciFar. Thank you for listening, and I hope you found it useful.